Morning everyone, so my name's Parissa and I'm an associate in the employment team at Fox Williams, and I'm going to be talking to you about the do's and don'ts of dress codes in the workplace. So as you all know, it's common for employers to have a dress code policy. It'll often be contained in the employee handbook, and this often sets out appropriate standards of dress. It's usually to maintain a smart appearance at work, but it might state things sort of more specifically that says you can't wear shorts, crop tops or flip-flops and other items like that. It sounds like it should be a relatively straightforward concept. However, you may have seen the recent media attention surrounding a requirement for women to wear high heels. And should this be permitted in client-facing roles? Or what about a requirement for women to wear makeup? Could there be any issues with this in practice? So what does the law actually say? Employers need to carefully consider their dress code policies because it can result in claims of unlawful discrimination on the grounds of race, religion, gender or disability, to name a few. So under the Equality Act 2010, discrimination can occur in a variety of different ways. The first legal risk is direct discrimination. And by way of reminder, the test for discrimination is where, because of a protected characteristic, A treats B less favourably than A treats or would treat others. So to explain how this applies in practice, if an employer requires all female staff to adhere to a specific grooming policy, for example having manicured fingernails, coming to work without oily skin, having a requirement for them to shave their legs, which is actually a grooming policy that the Dorchester Hotel applied to its staff, and do not have an equivalent policy for males, this may amount to direct discrimination which cannot be justified. So the second legal risk is indirect discrimination. So this is a little bit more tricky than direct discrimination, but by way of reminder, the test for this is where A applies to B a provision, criterion or practice, otherwise known as a PCP. B has a protected characteristic. A also applies or would apply that PCP to persons who do not share B's protected characteristic. The PCP puts or would put persons with whom B shares the protected characteristic at a particular disadvantage compared to others. The PCP puts or would put B to that disadvantage, and A cannot show the PCP to be a proportionate means of achieving a legitimate aim. So to explain how this test would apply in practice, if an employer has a dress code policy prohibiting signs of religious belief in the workplace, this will be unlawful unless it is an appropriate and necessary means of achieving a legitimate aim, for example due to health and safety reasons. So the concept generally of strict dress codes that may be more onerous on women than men therefore can cause employers a lot of issues, particularly when having to balance the needs of their business. So just by way of reminder, I've set out the protected characteristics, but the sort of two main areas of conflict we tend to see when dealing with dress codes are sex and religion. So what happens if we get it wrong? So if an employee is dismissed for failing to adhere to a specific dress code policy and they try and bring a tribunal claim, they could have claims for discrimination and unfair dismissal. So for discrimination, losses are calculated on the basis of an injury to feelings award, which could be up to a maximum of around £40,000, but this top element is quite rare in practice, and often employees would be expected to have an award much lower than this. There would also be an award for future loss of earnings. This is uncapped, but typically it could be 6 to 12 months net pay, but it could be higher, and it often depends on, a tribunal would look at how long it would take that employee to find another role. Losses in relation to an unfair dismissal claim, if they have at least 2 years continuous service, are calculated in relation to a basic award, which is by reference to age, length of service and weekly salary, and also a future loss of earnings, but that's capped at a year's pay or just over £80,000. But if an employee was trying to claim both, there wouldn't be any double recovery under future loss. And if the employee isn't actually dismissed, but still brings a discrimination claim, any award will just be limited to injury to feelings. So, the key question, is it lawful for an employer to require a woman to wear high heels at work? So as Helen explained earlier, Nicola Thorpe was sent by her employment agency, portico to work at a client's offices, to work as a temporary receptionist. When she arrived, she was told that flat shoes she was wearing didn't comply with their policy, and that policy included a requirement for females to wear heels with a height of between 2 and 4 inches. She was given the option to go and buy a pair of heels, but she refused. She was then sent home without pay. This obviously created a lot of media attention and a lot of outrage, and Nicola started a petition titled "Make it illegal for a company to require women to wear high heels at work." This opened in May 2016 and closed in November 2016 and had over 152,000 signatures. So, as a result of the petition, the House of Commons Petitions Committee and the Women and Equalities Committee carried out a joint inquiry, and they focused on hospitality, retail, hotels and tourism, travel and airlines, corporate services and agency work. So the report was published in January 2017, and it concluded that being required to wear high heels is damaging to female workers' health and well-being, and that some of the dress code requirements make some female workers feel uncomfortable and sexualised by their employer. So the report made 9 recommendations in 3 key areas. The government should take urgent action to improve the effectiveness of the Equality Act by reviewing this area of law and, if necessary, asking Parliament to amend it. More effective remedies should be available against employers who breach the law, for example, enabling injunctive relief against potentially discriminatory dress codes and allowing employment tribunals to award increased financial penalties against employers who breach the law. The government should also introduce guidance and awareness campaigns targeted at employers, workers and students to improve their understanding of the law and workers' rights. So, the government responded to these recommendations and, as expected, considered that the law was clear and the current protection in the Equality Act is sufficient, didn't consider that financial penalties or injunctive relief would be appropriate, although they are expected to publish later this year new policy on dress codes. So where does this leave us? Unfortunately, the report isn't as helpful as perhaps we first thought, and employers therefore have to look to case law to understand what's required in practice. However, unfortunately, there is a lack of case law on when a dress code might constitute discrimination, and it can also be quite contradictory. So, as gender and religion tend to be the main areas of conflict that we tend to see, the case examples that I've focused on are in those 2 areas. So, just to give you an example of some sex discrimination cases, in Smith & Safeway, the Court of Appeal held that having different requirements for men and women in a dress code will not amount to sex discrimination, where the dress code applies a conventional standard of appearance and taken as a whole, rather than item by item, neither gender is treated less favourably. A requirement for men to have hair not below shirt collar length, which didn't apply to a woman, was held to be lawful in the context of the dress code as a whole. And in the Department for Work and Pensions in Thompson, the Employment Appeal Tribunal held a dress code which required a man to wear a shirt and tie, but women only to dress appropriately and to a similar standard, will not necessarily be unlawful discrimination where an even-handed approach is applied and adopted in the context of the dress code overall. So by way of contrast, unsurprisingly in Smith & Rees, the Employment Tribunal found that a woman who was dismissed from her job as a waitress for wearing a low-cut top succeeded in her sex discrimination claim because obviously a man would not have been required to wear an equivalent uniform. So, moving on to the only interactive part of this session, I'm going to set out the facts of 2 cases that the European Court of Justice recently ruled on in relation to religious discrimination. So I'll then ask for a show of hands as to whether you think this amounts to discrimination or not. So in Akbitter and G4S Solutions, the facts were that Miss Akbitter is a Muslim. She wanted to wear a headscarf whilst doing reception work. G4S has a policy which prevents the wearing of any signs of political, philosophical or religious beliefs by any customer-facing staff in their workplace. As a result, Miss Akbitter was dismissed. So hands up if you think this amounts to direct discrimination, or any form of discrimination. Yeah, how about no? Oh, not so many for no. Okay. The answer is no, because the ECJ held that there hadn't been any direct discrimination because the policy of neutrality applied to all employees, whatever their beliefs. There hadn't been any indirect discrimination because there was a legitimate aim, which was the desire to display, in relations with both public and private sector customers, a policy of political, philosophical, or religious neutrality. The policy was found to be a proportionate means of achieving that legitimate aim, provided it was applied consistently and limited to what was strictly necessary, for example, customer-facing staff only. However, they did say it would be different where a policy specifically prohibits particular items of religious dress, for example, a requirement to wear headscarves, because this would be differential treatment based directly on an individual's belief or their manifestation of their belief in public, and would therefore be direct discrimination. So the next case, Miss Bugnayowi was employed by Micropole as a design engineer. She was sent to work at the premises of a client. She wore a headscarf and the client objected, saying it had upset a number of its employees. Micropole asked her to observe a policy of neutrality when dealing with clients. She refused and was sacked. Do you think this amounts to discrimination? Yes? Hands up for no? Oh, no one. So you're right. Yes, it does amount to discrimination. So the decision to dismiss an employee for wearing a headscarf in the absence of a specific policy would be direct discrimination. The willingness of an employer to take account of a client's wish wouldn't constitute a genuine occupational requirement, which would otherwise have provided a defence to direct discrimination. The ECJ distinguished this decision from its decision in Akbitter because Akbitter did not involve a customer's objection, but a general rule implemented by the employer. So Miss Bugnayowi's dismissal was not because she hadn't complied with an internal rule. So whether Micropole had a legitimate aim of pursuing a policy of neutrality in relation to its customers wasn't relevant. So they focused instead on whether Micropole's decision could be justified on the basis of there being a genuine and determining occupational requirement. However, looking at both of those cases, the ruling that in Akbitter that having a policy of neutrality for customers is a legitimate aim is actually fraught with difficulty, and it doesn't necessarily follow that employers in the UK can now apply this to their own businesses, particularly as both of these cases involved employees that were based in Belgium and France, which have a history of secular views, so arguably the same rules wouldn't apply to the UK. So I think UK employers overall do need to be careful if they are trying to apply a policy of neutrality. A more balanced approach was adopted by the European Court of Human Rights in the case of Awida and British Airways that you've probably all heard about already. But that was where BA's aim of projecting a corporate image and promoting recognition of brand and staff was held to be legitimate, but it didn't justify prohibiting the wearing of a necklace with a cross, given that the cross was discreet and didn't really detract from professional appearance. So what does this all mean going forward, and what can employers actually do in practice? So I've set out some practical considerations, but I think overall employers should ensure that employees are treated equally, and dress code shouldn't be more onerous for one gender compared to the other. Dress rules should be kept to a minimum to reduce the risk of discrimination. So health and safety or the need for facial communication might justify some restriction, but you must ensure that any restrictions have a legitimate aim and they're necessary to fulfil that aim. If employers want to adopt a requirement for neutral appearance, they need to have good reasons for doing so, and it should be applied to as few customer-facing roles as possible. And prior to dismissing anyone in these circumstances, it should really be looking for alternative non-customer-facing positions for an employee that's affected by such a rule. And finally, a reminder that the Equality Act applies equally to all potential employees at the recruitment stages, so you need to bear this in mind if you're refusing to employ someone on the basis of their religious dress, for example.